Good afternoon. Welcome, and thank you for attending. This is the session called the Tips for Embracing Diversity in Selecting Neutrals. I'm Sandra Smith Gangle. I'm the retired arbitrator from Oregon, Washington, and moderator of this session. I have to begin with a few housekeeping matters for everyone who is attending this session. First, we ask that you please keep your mute button on throughout the session to prevent interference from background noise. We strongly encourage you to ask questions by typing them in the chat. I will be reviewing the questions that come in while the speakers are giving their presentations, and I may direct some of those questions to the presenters, but others will be saved until we have completed the presentations, and there will be time at the end for the questions. Each of the presenters has submitted some documents for in place of handouts for the participants in this conference. And you can find those in the segment of materials that it's in the list of red items on the web page for the conference, and it's called Speaker Bios, Handouts, and Papers. And we have a number of documents there, including some documents that our speakers are going to be speaking about in their presentations. One is the American Bar Association Resolution 105 regarding the importance of including persons of diversity on all roster lists and referral lists that respond to requests from parties involved in disputes. And there's also a wonderful article by arbitrator Homer LaRue and another arbitrator, Alan Simonette, called the Ray Corollary Initiative, How to Achieve Diversity and Inclusion in Arbitrator Selection. And that is an excellent article that I hope everyone will take time to read because it is certainly very timely and thorough. Finally, if anyone would like to speak to one of us after the session, please put that in the chat and we can meet with you, I understand, virtually in a private hallway, what they call a hallway meeting, by clicking on the plenary screen for the conference. And we'll hope that that works and meet with you for a few minutes and answer whatever questions you have. Okay, now I'm honored to introduce my two discussants. They are two distinguished professionals in the dispute resolution community of labor relations. First, Michael Z. Green, professor of law at Texas A&M University and director of the workplace law program there, and a highly experienced labor arbitrator on many rosters, as well as the Houston police officer. And he is a member of National Academy of Arbitrators. Rebekah Ratliff is a highly experienced mediator of civil and employment disputes and a member of JAMS, the Judicial Arbitration and Mediation Service. Rebekah is also the co-chair of the ABA Dispute Resolution Diversity Committee, and she has received a congressional award for her ADR work from the 7th District in Illinois. And they will tell you more about themselves in just a moment, because that's how we're going to start our session here, is to tell you how we became active in the conflict resolution profession in spite of the obstacles of gender and race discrimination. As for myself, I was discouraged from going to law school because women were usually unable to find employment as lawyers until the Civil Rights Act of 1964 was passed and implemented. And finally, in 1977, at age 34, after 12 years as a foreign language teacher, I was able to pursue my dream and I became a civil rights attorney. Then I was fortunate to be mentored, and that's an important thing that our speakers are going to be talking about today. And my mentor was a law professor and a well-known labor arbitrator who was a member of the National Academy, Carlton Snow. He's no longer with us, unfortunately. But he gave me a roadmap on how I could become a labor arbitrator, which at that time was nearly 100% white and male. And so I was the first woman in Oregon to be approved as an arbitrator, and I'm very happy to have had a fine career, and I'm now retired. And I recently published a book that I hope some of you might be interested in reading, called Madam Arbitrator, about my roadmap and my career as an arbitrator. So at this point, I just told you my story because I think my life would have been, or my experience would have been quite different if I had been a Black or brown person, as well as a woman. The realities of implicit bias and risk aversion, which our discussants are going to tell us about, would have been much more serious barriers, preventing me from being chosen, I believe, as an arbitrator over these years. So I gather that our speakers are ready now to tell us about themselves. And I'd like to start with Michael and to tell us what your life story is and what you have gone through in your career.
All right, thank you very much, Sandra. I'd like to thank Lyra. I also thank Rebekah as the co-panelist. Happy to discuss this very important topic. I'm not sure you really want to hear my whole life story. Probably not that exciting to most of the people out there. I will try to frame a little bit of my background regarding how I got into the issue of dispute resolution. And as Sandra mentioned, mentoring has played a key role, but it starts with education. And from there, the mentoring and developing some expertise and mastery in the subject area of workplace dispute resolution ended up being the starting point for me. I had an engineering degree out of college, and I decided I didn't really want to go to school anymore. I just wanted to be able to get out there and work. And my first job was an entry-level manager at Procter & Gamble. Procter & Gamble prides itself on training their managers in human resource concepts. I became enamored with anything involving workplace issues and disputes. And they also paid for me to eventually go back to school, and I obtained my second out of my 5 degrees, getting an MBA at night while working at Procter & Gamble on various workplace issues. And as I would go through these various disputes and dealing with things like sexual harassment in the workplace and safety issues, they would always say, well, the lawyers are the ones who are going to handle these disputes. And I said, well, why can't I be one of those lawyers who would handle these disputes? And by then I knew I wanted to practice law regarding workplace issues. I was living in California and originally from Chicago. So I looked and I saw Loyola Chicago had a dual degree program where you could get a law degree and a master's in human resources and a master's in human resources and industrial labor relations. In that master's program, I met probably the first key mentor that kind of paved the way for me to eventually get involved with and become a labor and employment arbitrator. And that's Lamont Stallworth, who is a member of the National Academy of Arbitrators. He was my first professor in that master's program in a human resource law course and became a key mentor, motivator, and my desire long-term to become a neutral in workplace disputes. He sparked my interest in the subjects of arbitration and issues of race and wanting to write about them. From there, once I graduated with both of those degrees, I worked for a labor union firm and then mostly with management side firms. I decided after teaching as an adjunct that I wanted to become a law professor. And there I pursued my 5th and final degree, a master's of law at Wisconsin, where I met Jim Jones, another African-American male member of the National Academy, just like Lamont Stallworth. And during that process, I worked a lot with Jim and obtained a lot from his own mentoring. From there, I focused on becoming a law professor and writing about workplace disputes and the intersection of issues of race. While going through the tenure process, I became acquainted with another African-American National Academy member, former chair, first African-American chair of the National Labor Relations Board, Bill Gould, also one of the first Black members of the National Academy. And his writings and research and work on diversity also guided me. After I became tenured, I decided that I wanted to be more specific and pursue efforts in labor arbitration. And then I met another member of the National Academy of Arbitrators and also a mentor in Floyd Weatherspoon. Floyd Weatherspoon had been developing a program on minorities and dispute resolution and having annual programs. He was a professor at Capital Law School, and I went to one of the programs, and they had a specific program in conjunction with the Federal Mediation Conciliation Service training to get on their panel to become an arbitrator. And it was a wonderful program where there are approximately 20 people or more, all African Americans, all with great backgrounds who wanted to become labor arbitrators and went through that training. A number of us who were in that training have now become members of the National Academy of Arbitrators. And that's kind of what led me to become eventually doing arbitration, become a member of the National Academy. And as a law professor, I've written about 3 or 4 key articles addressing race and diversity in arbitration. So that kind of explains my background and how I got to this point through the help of some really key mentors, education, and trying to develop some mastery in a particular subject of workplace dispute resolution.
Thank you, Michael. Certainly, you have a very impressive history, and it's very clear that the road to becoming an arbitrator is not slow and it's not fast. It is slow, and you have to be deliberate and be willing to be patient and go step by step and listen to your mentors. And I think that was very good advice for other people when you told your story. Rebekah, would you like to tell us your story about becoming a mediator?
Yes, thank you, Sandra. And welcome to everyone. Thank you for joining us today. Thank you, Sandra, for the invitation, and obviously very honored to be with you, Michael, today. I'm Rebekah Ratliff. I am a mediator and arbitrator with JAMS. And so I'll tell you a little bit about my path to that. I actually have a psychology degree from the University of Illinois at Urbana, and didn't actually see my career path the way it is, but very grateful that it has been my path. I grew up in a suburb of Chicago, Maywood, Illinois, and if any of you are basketball fans, you know Proviso East High School very well, home of Doc Rivers. So nobody ever knows where Maywood is except for that. So grew up in Maywood. Fortunately, I'm not first generation college, so I had some direction through my mother. My parents were amazing. I'm the daughter of a pastor and a nurse, so come from a community at home and around that cares about people. Servant leadership is the background that I come from. So got my degree at the University of Illinois, and then I fell into the insurance industry. I spent 25 years as a commercial claims professional. And as my career grew, I got into complex claims, so civil torts in lots of areas of expertise, to include medical malpractice, commercial premises liability, products liability, municipal liability, nursing home, lots of different types of cases. Never turned down the opportunity to learn. So I managed, evaluated, and negotiated cases across the country, almost all 50 states, and international, because I worked for global carriers. The last 10 of my 25 years was with Chubb Insurance, which is now the second largest insurance entity in the world. So was very proud to work under the Chubb brand, and have always had mentors, like what Michael said in his intro. I've always had mentors, and I have a panel of mentors. Probably they don't They don't interact with each other, but they all serve different purposes for me. And I've been very fortunate to have those people in my life. So in my career, towards the end, I was thinking about next logical steps. I enjoyed what I did as an adjuster, but I happened to be speaking to a mentor who I will name, Judge Gino Brogdon. If you watch Court TV, he's the judge on personal injury court. And he's my mentor. And he said to me, you are doing great work as an adjuster, but you are living beneath your skill set. So I had to have somebody tell me that to actually kick me out of the nest. I did enjoy my career as a complex adjuster. And again, I handle global claims. I speak fluent Spanish. So I enjoyed all the different interactions that I had in my career, but it was time to do something more, not necessarily something better, but something more. And so I took his advice and I left my claims career and I founded Capital City Mediations in Atlanta, based in Atlanta. But the other piece of advice that I got from him was, you are a case evaluator and lawyers will pay you to tell them what their cases are worth. So in addition to becoming certified as a mediator and arbitrator, I also, the third prong of my business with Capital City Mediations was case evaluation. And that's how I established myself nationally. So I gained a national footprint in relatively quick amount of time. But the other point that I have to mention is that I joined trade associations. I happen to be the president of the Atlanta Association of Insurance Professionals. It is the local chapter of NAIA, the National African National African American Insurance Association. My chapter is the largest of 17 chapters across the country. And with that, I also joined legal trade associations, the American Bar Association and the National Bar Association. For the ABA, I am the dispute resolution sections. You heard it in the intro from Sandra. I am the diversity committee co-chair. And for the National Bar Association, I am the second vice chair of the alternative dispute resolution section. So the point is, I serve. So as we're talking to you today about, how to get selected, how those interactions should benefit you in your practice, also consider the service piece, because when you serve, you're visible. So I do a lot of speaking all over the world. I publish articles. And I serve in trade associations to make sure that I'm visible, because as a Black female, it's very necessary to stay visible. But I do the work so that I can gain, we'll talk about mentorship, but I'm also going to bring up sponsorship and allyship today too, because some of us in the audience can be allies. And so I just wanted to put that out there. So now I'm a mediator and arbitrator with JAMS, which I enjoy very much. I'm based in Atlanta, but I provide alternative dispute resolution services worldwide with JAMS.
Thank you, Rebekah. What you have pointed out very clearly is that the route to becoming a conflict resolver can take many different faces. You don't necessarily need to have a law degree. You don't need to pursue a legal strategy. You can get your expertise through your knowledge of other kinds of disputes and through your experience negotiating and reaching agreeable solutions with parties. And so it's that talent. It's the talent of being able to be both an advocate and a dispute resolver that in whatever kind of practice you have, that is very valuable then in the long term. And also, of course, it's important for those of us who did come from the legal background to not just be from one side, but to have had experience representing workers as well as people on the management side, so that we know the issues from both sides of a dispute that would come before an arbitrator. And I appreciate your comment about giving service, because that is a requirement. That is an ethical requirement of arbitrators. and mediators is to give back to the community and to share your talents and what you have benefited from becoming a neutral with others on some kind of a voluntary basis. So thank you very much. I'm going to move on now to the next question. It has to do with the selection procedures for choosing neutrals. As you know, that usually there's some kind of a random list of proposed neutrals that goes out to the parties, and then they choose on a party by party basis. They strike the names of the parties of the proposed neutrals that they do not wish to have served. So my mentor, Professor Snow, always told me, keep in mind that when you are selected, it does not mean you were the most desirable. It means you were the least undesirable, because they get rid of the ones that they do not want, and you are left as the individual that is chosen for the case. But then we've talked about this, and are there some issues with that process? Do you believe there are some problems for persons of color and women who may not be well known to the parties, and therefore they may have their names stricken simply because they are unfamiliar? The parties do not know who they are, or they suspect that maybe they do not have the right kind of talents or abilities or frame of mind or ethics, whatever, but they don't really know the party, the person. And therefore they strike the person. And so sometimes the individual, or oftentimes the individual, because they're not a white male, just simply doesn't have the opportunity to become known to the advocates who are selecting them. So I think that I'll start with you, Rebekah. I think we call this kind of potential risk for arbitrators, potential arbitrators and mediators, an issue of implicit bias. Can you give us some ideas on what is implicit bias, and how might all of us be guilty of implicit biases?
Sure, thanks for that. Well, what we know is, statistically speaking, the lack of diversity in the ADR field mirrors the lack of diversity in related insurance and legal industries. And something that started off conscious kind of resulted in unconscious consequences. Implicit bias in selection is, implicit bias is unconscious bias, biases that we have on the inside that are not conscious to us. An article, I think that I forget now, Sandra, if it was the article that you sent to us, or another article that kind of had a nice analogy where, our known biases are like the top of the iceberg that you can that's visible. But what we've seen, if anyone has seen a diagram of an iceberg, is you have a point that shows, and then the depth of the iceberg under the ocean that you don't see is 10 times deeper than the piece that you see. And so that was an analogy that I saw about unconscious or implicit bias, where we're guided, our behaviors are guided by what biases we have that we know of, but the ones we don't know of sometimes influence our behaviors that that we end up seeing or that affect our work life and how we interact with people. And so implicit bias in selection is enabled by a structure that historically excluded minorities who were Black, Hispanic, Asian, female, and other diverse groups. And I know that race is an uncomfortable topic. So let's agree in this session, if you would, that we're all going to get comfortable being uncomfortable, and consider that we all have unconscious bias. And what's been explained to us by the scientists is that our brain chunking process, our brain attracts and inclines us towards things familiar. And, an example of that is the selection of people who, as you've mentioned, Sandra, are familiar to us, someone who even is referred by somebody that we know. And then there are great neutrals out there whose resumes we never get past or get to understand their backgrounds and skill sets and culture benefits to the mediation and arbitration process. we never even hear of those people because familiarity and implicit bias, the way we select what we're comfortable with, things we see and people we know. This is it affects the process. It affects the process. And so I wanted to mention the Harvard implicit bias test. That can be easily found on the web. But the key through selection is to ensure that the list is comprised of neutrals who are ethnic, gender, and sexual orientation diverse. And it's going to take conscious effort. It's going to take more effort than we know has been given in the past. And so obviously this session and other sessions that we're hearing in recent times are geared towards the awakening that's happening and the encouragement and hopefully the influential conversations to increase the number in selection of diverse neutrals.
Thank you. It's a complicated issue, and most people are unaware that they have implicit biases. But when it's pointed out to them in ways that make sense, then the reality sinks in. And the more we read, and there's a lot in the media right now, isn't there? A lot of articles are coming out about implicit bias. And I think people are becoming more aware and are realizing what's entailed and how it affects every one of us as human beings. Okay, I think that I'm going to ask Michael about the risk adversity. How is it that some of the people that are choosing, people that are that receive the roster lists and then decide who they're going to strike, what is the risk that's involved, and why are they afraid to take that risk?
Well, I think when you look at the people who are actually deciding, so when you and we'll probably get to this maybe the next question and thinking about how we deal with this whole selection problem, but when you get a panel and it has a list of potential dispute resolution providers on there, and the parties who are the gatekeepers, the ones who are deciding who will be eventually become the arbitrator. And as you said, Sandra, talking about your mentor telling you were just the one who was not the most liked or the worst liked, but kind of the in between for them. That process in itself, basically, if you're a gatekeeper making that decision, and certainly you want to win in arbitration, right? You're selecting a neutral service provider, but you want to win. And so in your mindset, you are picking the person, hopefully, as you break down through those strikes, you get the person who will most likely accept your arguments, your positions, and rule in your favor. Well, how do you make that determination as to who is the best person to rule in your favor? Well, obviously, if you had some prior experience with that individual, if you have had disputes with that person, or you know that person and their expertise, you interact with them, you know about their demeanor and their way of dealing with things, that familiarity plays a role. Right? Sometimes people say familiarity breeds contempt, but familiarity in this context breeds satisfaction and comfort to the gatekeeper that they are picking someone that they feel more comfortable with because they know them already. And people they don't know, they feel that that's more a riskier decision. Right? That's a wild card. That's someone that they feel like they cannot really assess. Now, this is also where what Rebekah was just talking about, where issues of implicit bias could certainly come into play, because who are you more likely to know? And who are you more likely to have experience with? Certainly, there's more likelihood that those will tend to not be people of color and women as the dispute resolution providers. Just yesterday, I was called to give a commentary for a lawsuit brought in Texas, where one of the parties is claiming and has joined American Arbitration Association in the suit, saying that he's not being provided with a diverse panel. And the defendant in that suit is saying that that's ludicrous, that they're just picking the most qualified people. They did not consider race. They did not consider anything else. They're just picking the most qualified people. Well, then you have these, maybe if it's not conscious, then these unintended consequences where you just continue to perpetuate the racially and gender stratified network of dispute resolution professionals out there by continuing to replicate and select the ones who fit that profile. And that risk is out there because the gatekeeper, the selector, doesn't want, in their mindset, to lose. And they really don't have any motivation to say, well, should I be maybe selecting someone who's more diverse? Should I be being more inclusive in my decision-making? When if they certainly do that and lose, how do they justify that when they're focused on winning? So I think that gets into the risk aversity issue for the gatekeeper in trying to deal with this issue.
Thank you. You raised an interesting point that people argue that they always look for someone who is qualified, because you wouldn't, the names would not be on the list that is proposed by the roster keeper if those individuals had not already been vetted and deemed qualified. So that is the mere fact that they did not know the person does not reasonably lead to a conclusion that they're not qualified, does it? So you're right. Now, there have been some recommendations recently on ways to get beyond the risk aversity, perhaps. And so I'm going to ask you if you can address those now. One of them would be the idea of pledges, or looking at commitments. So could you talk about that, the ABA pledge, Rebekah? And then I'm going to ask Michael to talk about the Ray corollary, which is another way that has been a proposal that has come up recently. And so I want to give each of you plenty of time to do that. Rebekah, would you start?
Okay, sure. Thank you. Well, there are initiatives focused on increasing the selection and use of diverse neutrals. So the lack of diversity in AER, as we've said, mirrors legal and insurance, and the ABA Resolution 105, which was adopted in 2018, is focused on the efforts for providers and domestic and international providers to expand their rosters with diverse neutrals. So they, the optimal result is to increase not only selection but use. And the Resolution 105 effort is now under the purview of the Diversity Committee for the ABA, of which I'm the co-chair. It is a short read and it's accessible, and I do believe it's included in the materials. But Res 105 is soon going to be amended to include the Ray corollary, which I know Michael is going to talk about, but it was named after Charlotte Ray, who graduated from Howard University Law School in 1872 and was the first Black woman to be admitted to any bar in the United States. Yes, and the Ray corollary, I happen to be on that strategic task force. It uses a metric, a 30% metric in the final selection process, and relies on measurable results. So I'll let Michael talk in detail about the Ray corollary, but it was created, as you said, by Homer LaRue and Alan Simonette, and it's bringing more awareness to the disproportionate selection reality and with the call to action. Michael.
Oh, okay. Thank you, Rebekah. I was going to let you take that with the Rooney Rule. You were going so with the Ray corollary. You're going so well. I mentioned a Rooney Rule, and if you're familiar with the National Football League and what they have developed is called the Rooney Rule, and I know Homer LaRue is the main proponent, along with Alan Simonette, of the Ray corollary and he thinks this should not be a rule, it should be a corollary. I'll let you look up what the dictionary definition is of the difference between a rule versus a corollary. It sounds like something a law professor might delve into. But under the Rooney Rule in the NFL, it's intended to, whenever there's an opening for a hiring of a head coach, it requires that a certain percentage of the people that you interview for that position have to be African American. And so kind of basing upon the Rooney Rule, and Rebekah talked about the history of Charlotte Ray and how they came up with the name, the Ray Corollary Initiative. It's a detailed plan for action to increase the number of diverse persons selected as arbitrators and mediators by establishing this 30% metric. And I know Sandra referred to one of the documents we provided to you is the actual article that's written in the Howard Law Review by Homer and Alan, Homer LaRue and Alan Simonet. And it goes into more detail about some of the science behind why that 30% metric is an important one in terms of it having at least that kind of critical number of people of color in the process of selection, and how that kind of basically will give you some kind of opportunity to really develop and expand upon the number of diverse persons who are selected. And by requiring this 30% number, you actually can respond to the challenge. And there's a challenge here, which I call basically not only a supply issue, but a demand issue. And what I mean by that is that in some aspects, there certainly is a supply issue, right? The number of people of color and number of women in our society who are eligible to be in certain panels or whatever, certainly is less than probably white males who have historically been in those positions. And so you want to increase the pool. So you want to make sure there's more people in the supply side. But this demand issue, which goes to the risk averseness, is even when you have qualified people who are on these panels. And Sandra, when you mentioned that example I just talked about, where the case in Texas, where they were saying, well, we're selecting the most qualified people. Once you get on the panel, as you said, that there's already been some vetting done that suggests that you are qualified. So once you have a requirement like a Ray corollary rule where 30% of the panel has to be diverse, then it makes it more of an opportunity to not just rely upon someone you used before, and therefore perpetuate the lack of diversity. So the corollary initiative is certainly a major way to do this, a major way to kind of hopefully change this impact of diversity. I want to mention one other suggestion too that is mentioned in one of my articles that's in the materials. It's an article I published last year in the Fordham Law Review called Arbitrarily Selecting Black Arbitrators. And what I suggested, and this goes to what Sandra was mentioning about these panels, I'd like to see it where if the parties actually buy into the service providers really doing the heavy lifting and finding qualified people, and that's dealing with the supply issue, but if we move up the supply, that once you request an arbitrator, to cut out this process of striking and letting parties select, just randomly provide an arbitrator for the parties. Similar to what would happen if you were to go file in court. You don't get to get a list of the judges and strike that one and strike that one. You just randomly provided a judge. And so that was my suggestion of another way to deal with this issue.
I like that, Michael, because the pipeline is not really the sole issue. It's selection. And with the rate corollary, the target organizations and groups are in-house counsel, ABA sections, law firms that select lawyers, law firms that select mediators and arbitrators, rostering agencies, ADR member orgs, plaintiff bars, and defense bars. And it's, the onus has to be on the selectors, not just the providers of arbitration and mediation services. What we're trying to do with the rate corollary is, because to the point, because I don't know that I gave any real detail on the 30% metric. The statistics show that at least at 30%, and you hit on it, at least at 30%, the selection is likely to be disproportionately higher than if it is not, at least 3 out of 10 at least. Then there are chances that a diverse neutral may be picked if that's the commitment. So the pledge that that we have, obviously the ABA has the resolution, but in concert with that will be the pledge. And the pledge is asking these target organizations and groups to actually produce a document or a diversity statement that commits to the 30%. Being on those lists for selection to encourage, and there are going to be some efforts. I'll tell you, there's another effort underway right now between the insurance industry and some of the affinity bar associations with the minority mediators and arbitrators. We want to have a full circle view at the ADR profession, because insurance touches everything. ADR touches obviously I'm a daughter of the insurance industry. Legal touches everything. And so those interdependent disciplines, have to have some agreement, in them where we are including the selectors of neutrals and asking for a commitment that they are willing to, to put on paper really, and incentivize the selectors, defense attorneys, for instance. What is being looked at? How do we incentivize them to, it's sugar, always sugar, never salt. This is kind of how I was raised. And so you want to make the case for why, diverse neutrals serve the communities well, better than just a monolithic look. And so there are lots of different complementary efforts underway. But the rate corollary is a call to action with a specific metric.
Thank you. Those are great points. I'd like to follow up on the suggestion that Michael made about having the roster provider do the random selection. And I think that would require, of course, the parties to have agreed that that is acceptable, because their collective bargaining agreement probably, requires that they have the input in choosing who it will be. And I know that that's one of the things that might be recommended for parties to consider, is the next time they negotiate their collective bargaining agreement, fine tune the language of the dispute resolution provision in the contract, so that it would allow the roster provider to choose the according to, on a random basis, among the arbitrators, and to choose a percentage based upon how many cases come in, choose an arbitrator of a race other than white. That's one way, but there are other ways of getting to know more about the arbitrators of color. And I think that part of the problem is that so oftentimes, because of the difference in race, there is the lack of familiarity of the underlying growth of the people that then become arbitrators, and therefore there must be ways that they have a chance to see you rather than just see your name and your resume in black and white. It just is a very not a warm, fuzzy, a human kind of getting to know. Aren't there ways that you could recommend that the parties be able to get get to be known better, like meets and greets. I mean, how can these be set up? Are there other ways of getting beyond they're unfamiliar to me argument?
I think so. I think that because of the list, there are lists that exist. For instance, the National Bar Association has a certified list of neutrals, arbitrators and mediators ready to work across disciplines and across subject matters. Arbitrators of African descent is a list. And that list was put together by Dr. Catherine Simpson and Nancy Thevenin. That is a list of, I think, over 200 arbitrators of African descent. Then there is the Hispanic National Bar Association, the HNBA, the NAPABA, which is National Association of Pacific Asian Bar Association, I think National American Pacific. I know I'm saying it wrong. I don't mean to say it wrong, NAPABA. But you can hit the resume links on these lists. Also LinkedIn, there are connections on LinkedIn. As a matter of fact, for selectors, some of the sessions that advocates or selectors are on, you can just kind of have to do a little bit of work, but like grab some names and look on LinkedIn and look at the bios and what the background experience is, and you'll see the culture of some of the neutrals. Publications. If you're looking at publications for neutrals, you'll get to see some of their subject matter expertise areas. Video resumes. Some of the providers have their neutrals highlighted on video resumes on their websites. And then there's YouTube. There are videos and there's work that some neutrals are doing that are recorded on YouTube that you can get to. You can also ask providers for a diversity scorecard. If you use JAMS, for instance, JAMS has a search capability for diverse neutrals and a utilization tool, so people can see how they're doing. You can incorporate an inclusion clause, and JAMS happens to have an inclusion clause. There are programs. You're going to see more diverse neutrals coming and ready to work, because there are programs such as the AAA Higginbotham program, the FMCS, they have a program. CPR has a Pathways program, which is an abbreviated application. And JAMS has recently implemented our fellowship program. So again, more onus needs to be put on selectors, not just the providers. But if we are really committed to this effort, there are ways to find the diverse neutrals who are ready to work.
Yeah, thank you. Maybe Lyra could sponsor a couple of sessions where arbitrators who feel that they are not very familiar, the parties aren't very familiar with them, could get together and have a session of just, here I am. I'd like to talk to you. I'd like to present my credentials online and answer your questions. And then that would be open to advocates from both labor and management on a neutral basis to get to know you better. Did you have some ideas, Michael?
Well, I hate to be the sourpuss on the panel a little bit. I actually think that, to me, the supply issue is more of a red herring, and the getting to know you thing is really a misnomer. I mean, usually when people select an arbitrator, do they really say, I kind of like to get to know you a little better? Maybe we need to go out and have some drinks and talk what your philosophy is or whatever. They don't really need to know you personally. It's really, do you have the credentials to serve? And now what they do need to do in the selector process is, if there are qualified people that if they really are committed to diversity. And the reason why I say I'm a little bit hesitant about this, Home of the Rule and Marvin Johnson were involved in a program called Redress, where they were working with JAMS actually to provide mediators of color. And they got a cadre of really experienced mediators of color, and worked with companies who care about diversity, have strong diversity statements, and they still found these people were not getting selected. And so it was even when they knew people who could vouch for these people and knew that they were excellent candidates. And again, it goes back to that risk aversity thing, because it's not whether they know you, it's whether they know somebody who they feel they're more comfortable with will help them resolve their dispute in the way they want it resolved. So it's really about giving others a chance. And I think that's what some of the Ray Corollary Initiative or both JAMS and AAA do things to kind of really make sure that their service providers are diverse and they can run algorithms and do things to check on this. And it's really a commitment by those selectors not to really get to know, because they're out there, right? And these service providers want them on their panels, because they don't want to be criticized for that. So they're on their panels already. It's more getting the selectors to say, you know what, I got to maybe try it in a labor. You talked about changing their collective bargaining agreement. Maybe in a labor dispute saying this is important to us, maybe on a smaller issue. Maybe it's a small contract interpretation issue. We're going to select somebody we don't know that's diverse, and let's try them out and let's see what happens, because it'll be resolved the way you always resolve with all arbitrators, which is if it didn't work out well, we'll never use them again, but at least give them a chance.
Good, very good point. One of the items, one of the suggestions that has come up through our dispute resolution section in LIRA has been the potential of a triage system where the parties in collective bargaining cases, disputes, decide whether it's a simpler case or a more complicated case. And maybe they're more willing to take more risk with newer people, whether they female, male, or whatever. That would give them a chance to see how that person would conduct a hearing and then write the decision. Whereas in a complex case where they really feel that they need someone that has been, in the National Academy for 20 years to decide, well, then they can have a more clearly defined choice. But all cases are not the same, and therefore maybe they could be split, and simpler cases could give more of the newer people a chance to show their mettle, so to speak, and become better known. Another thing that you mentioned is that the advocates themselves sometimes have some kind of preference. They don't want to take a risk on somebody from a minority background that's different from theirs, and they feel that the difference itself is going to be against them, so to speak. Let's face it, most of the advocates are white, and therefore what we need is a more diverse system whereby the workforce, which is now 40% non-white, is able to get promoted and move up in the ranks so that they become the leaders of the unions, the leaders of the management groups, so that they can then be the ones that are selecting. And for them, then it's the race is not an issue at all, because the cadre of arbitrators looks just like the cadre of those who are choosing them. And so the whole issue of bias and risk aversion can go away if the people making the choice looks like the workforce and the cadre of arbitrators. So that's really what we need, right? Is everybody.
I think in the public sector, sometimes you will see more of that because they're more unionized in the public sector. The ratio of more people of color in the public sector. And in fact, I serve on a public sector panel where I brought one of my students to visit, and I hadn't even noticed it, but they just said everyone there was African-American. The union rep was African-American, the grievant was African-American, the attorney for the employer was African-American, the witnesses were all African-American. So I never even thought about it. But, if you have more of those examples, and that's where also you can get that experience, right? Because part of it is getting the experience. That's why I'm talking about the selectors giving people a chance. And if they do that, then you'll have that experience to draw upon when the more complex, the more risk-averse situations arise.
I found that myself when I was building my practice, was that the advocates in the public sector were more willing to try out a woman arbitrator than those in the private sector, who were a bit more of the white male types. There have been a couple of points raised in the chat that I will communicate to you. One is from an arbitrator, Betty Widgeon, who says we can all take advantage of the virtual world. In other words, the one that we're in right now, and suggest that we get together via Zoom, which is a pretty safe venture, or bring along another individual on both sides just to meet and get to know each other better. Again, a type of meet and greet process. She says there are so many virtual meetings and many of them are free. And she always looks for faces that she hasn't seen before and tries to reach out to them after the meeting. So I think that's something that can be initiated by anyone who has access to a Zoom process. Keep in mind again that they always have to maintain the neutrality, and it's best to be dealing with representatives of both labor and management together and not just one group. And then I had a comment from Lee Hornberger, who says the new list, arbitrators of African descent with a US nexus, is a website, and he put that in the chat. So I'm not going to read it to you, but that will be, you'll have available anything that is in the chat after the meeting. So then I think we just have a minute or two left. And so I'm going to just kind of let each of the people give a final little comment, something that you haven't said up till now, and we're going to have to sign off. Would you like to begin, Rebekah?
Sure, thank you, Sandra. Well, these are my parting words. Implicit bias is a factor in how institutions hire, promote, and select, and we cannot unsee our personal and professional exposures and experiences. Neutrals of color are considered and are not considered or selected equitably, and I would ask that our colleagues become champions to adding a building block to the infrastructure of the selection of diverse neutrals, and in categories that we've thought of and some that we haven't thought of. To enhance the ADR experience overall. Ally is a noun in the dictionary, but when put to proper use, it is a verb. Pulitzer Prize winner Isabel Wilkerson, in her most recent book, Caste, talks about the caste systems from a global perspective. And there are other great books, but I'll only name that one. If you're a selector, I just urge you to be intentional about engaging methodologies, strategies, and solutions to move together towards a more equitable selection of diverse neutrals.
Thank you. I recommend the book Caste as well. That was a very good suggestion, Rebekah. How about you, Michael? Do you have a final comment for us?
Sure. When you think about the selection of neutrals for resolving disputes, part of the question is, do the parties have the bargaining power on both sides of the dispute to make sure that the person who is the neutral is part of an inclusive and diverse group of people, so that even a diverse claimant has the potential of seeing someone that might look like or sound like them. That's an important aspect of any dispute resolution process in terms of the actual and the appearance of fairness of that dispute resolution process. In the court system, you have something called the Batson problem when you select jurors, and if a prosecutor or an attorney were to strike a juror solely based upon their race or gender, that would be prohibited. when you take a dispute that is a legal dispute and shift it into arbitration, and you do not have a mechanism like a Batson process to put a check on it, it becomes incumbent upon all of us involved to make sure that that process is fair in practice and in reality for all the participants, so the dispute resolution system is deemed fair.
Thank you very much. This has been a well presented discussion, and I want to express my sincere gratitude to Rebekah and Michael who participated today, and I wish you all the best in your careers. And also thank you to the audience for participating today. I hope that we gave you some tips on diversification, the value of it, and how we can further diversify the cadre of active arbitrators and mediators. And I hope that you'll consider reading my book, Madam Arbitrator, when you get a chance. It's available on Amazon. So with that, we'll close, and thank you all very much, and enjoy the rest of the conference. We'll
Thank
sign
you.
off. Mhm.